occupation is an occupation which will never allow them to come out till aided by what we call affirmative action. The reason is, Muller, that there is a condition. We are all, as human beings, victims of conditioning. We are conditioned to believe that everything is all right. We are conditioned to believe that things are the way they are because they are meant to be. Oft-heard dialogue is, my lord, if these people were not to do this job, who else will? And that is the reason these things should remain as it is, but that definitely is a mindset we need to shake ourselves out of. There are no ironclad barriers, my lord, which should keep the backward confined to their backwardness just because what they do is what nobody else would do, and their not doing what they are doing will not suit the entitled. That is the answer. We have to change these prejudices. We have to change the mindset. The problem is the resistance. The problem is the resistance to change that mindset. The problem is that it seems like a huge shift in a societal mindset to steer ourselves away from it and think that why can everybody in the society not be equal? And as we go along, Bullard, the core issue here is not only the advantaged and the disadvantaged, but the more advantaged and the more disadvantaged within the disadvantaged. That is the issue that we are addressing, Your Lordships. Undoubtedly, my lord, the change has to come at the grassroots level of society. Undoubtedly. What happens in the mind is controlled by exposure, mostly to what is taught in each and every household of this country. That has to change. But it still does not take away the obligations upon the state to aid and assist this change, which either in the form of bringing about a law by the legislature, decisions of the executive, and more important than anything else, the laying down of the law by your lordships, which will eventually bring this change. Because once your lordships lay down a law, the acceptance of a proposition goes up tremendously. Because your lordships say so, there is a dispensation of the public to follow the law. So from either of these three wings, if an assistance and aid is coming in achieving these results, it is more important than the other. We cannot downplay any part of this. Because, as I put it, Mullard, normally when we argue cases of reservation, a very common plea is raised that, my lord, I have 99% marks. I am being ousted by a person who has 56% marks. Is that fair? Yes, it is. It is fair because the person who has 56, he never had the means to be brought up in a family that you've come up in. He never had the means to go to a school that you went to the college that you went to, and to the competition preparation that you went through. And today, 99 is not your achievement. It is a conglomeration of all the factors that you've been through. That 56 is in spite of the factors that that child has been through. He has today reached 56, starting from 0. Your ride has been of an airplane from your birth. This person has walked his way to 56. That is what we need to understand. That the person who got 56 had no access to a dignified life. He was brought up in a neighborhood which did not give him any access to good education. What to talk of employment? And eventually, my lord, what are we striking to achieve here? By way of employment, we are wanting to make that person a part of governance. He has to feel that I am a part of running this country. I am a part of aiding the growth of this country by getting employment. That is why we'll mostly be, my lord, on 16.4. So for that purpose, the obligation of the state is best discharged by affirmative action under 15.4 and 16.4 to give this person who is backward access. We have to give him at least an opportunity. I will go as far as to say, my lord, that the old phrase that you can take a horse to water, you can't make him drink. We will have to make an effort to make that horse drink, because that horse has never seen water. That horse does not know that it is this water, which will eventually quench his thirst for becoming a part of governance. He wants it, but he doesn't know how to get it, because he's stuck in a cycle of occupational drudgery, which the society doesn't let him come out of. Though opportunities are available, but they are not being capitalized because of, I would not say the intent, but the effectiveness of the implementation is lacking. But eventually, if we all agree on this, that the goal is equality of opportunity, then what we urge before your lordships today is that measures need to be taken to make this goal not illusionary or formal, not a mere provision on paper. These goals do not have to be illusionary or formal, but actual and effective. They have to be end-oriented. If I can put it simply, they have to be end-oriented. Results have to show. And in this, there is a heavy onus upon the state, either at the center or the state level, for achieving this equality of opportunity. But this implementation has happened in phased manners. There have been amendments in the Constitution. There have been large number of executive orders, memorandums, laws, legislations brought out by various states. One of them of my state is under challenge before your lordships, from where this litigation arose. Just to put it briefly, though it's not a relevant issue that your lordships would be deciding. In Punjab, we brought out an act in 2006, where out of the posts which were reserved for the scheduled castes, 50% of the posts were reserved for Balmikis and Mazhabis.
That was your first circular which you brought out.
This was not circular apart. This was the legislative act which was under challenge.
The circular preceded the
yes,
because the circular had been struck down
That's
initially
right.
for want of legislative
That's
sanction.
right. So therefore, the legislation in 2006 and section 4, subsection 5, reserved 50% of the posts for Balmiki, Sikhs and Mazhabis. And there is a twofold implementation which saves it from the vice of discrimination and reverse reservation and reverse discrimination as we know it. This reservation in the 2006 Act was done on a twofold check and balance. One, that this reservation was limited to 50%, which in the development of law, Mulad, has become the Lakshman Rekha, which we are all advised not to cross. And the second check and balance was that this was implemented on a preferential basis. So, Mulad, as I would say, this was not an act of exclusion by any standard. By any standard, what Chinnaiah, Mulad, seeks to say is that this would be an act of exclusion. No. This was, if at all, an act of inclusion of those who were the most backward of the backward, to bring them, if not at par, at least up from where they stood.
Mr. Advocate General, when you said that it was implemented on a preferential basis,
That's right.
Can you elaborate that? How is it implemented on a preferential basis?
Lord, so suppose there are 10 vacancies for scheduled castes in a particular year or a particular recruitment. 5 were reserved for Balmikis and Mazhabis.
Right.
If they were available. And if they were not available, it was to go to SC others, which are Ramdasiyas and other scheduled castes, which were available. So in every recruitment, one would ensure that 10 scheduled castes definitely came in. But at the first instance, the right of preference of 5 of those 10 was to go to Balmikis and Mazhabis.
So there was no carry forward for...
carry forward was Bullet and block.
For the SC together?
Yes.
But not for the Balmikis and the Mazhabis Sikhs within the SC?
They were exhausted within that recruitment.
Yes.
So therefore, if I can put it in cost-effective way, this preference-based reservation was not at anybody's cost. It was not that if they did not get it, nobody would get it. If they did not reach the Mulad cutoff for getting that reservation, a scheduled caste only would get it. And your lordships are right, those scheduled caste vacancies were to be then, in common law, Mulad, as we all know it, to be carried forward and not counted towards reservation, this, that, and the other. All those parameters were to follow. It was not that they would either be converted to general or not be filled up and left vacant. There's nothing of that sort. There's nothing of that sort. So therefore, that is the core, Bullet, that if you cannot even as much as give preference to somebody who's really needy, without that being at the cost of somebody, and that act of the state government is quashed, is that correct? We are here to urge that before your lordship. Now, my lord.
Actually, Mr. Advocate General, there is an element of exclusion. I mean, let's not gloss over it. The point only is this, that because, you know, the same exclusion which applies to reservation per se
of excluding merit, as we all put it.
Posts are reserved.
Yes.
Once posts are reserved for a backward community, A, there is necessarily an exclusion of the forward community in competing for those posts, right? Yet our constitutional jurisprudence permits it. Why? Because we treat equality as a substantive equality, not formal equality.
That's right.
Therefore, post N.M. Thomas, we have now developed jurisprudence to the effect that reservation is not really a breach of equality, but it's
in aid of equality.
But the same, interestingly, the same argument which applies for reservation for the backward communities as a block, the backward versus forward, would also apply within the backward community, because what now we are really doing here by the measure which the Punjab legislature brought about was this, that within the reservation of seats for the scheduled castes, which is 15.5%, we'll take it for a moment, you know, I mean, just as a benchmark.
That's right, as a ballpark.
Out of the 15.5%, which falls within the overall 50% cap, 50% of the 15.5% is reserved for the Mazhabi Sikhs and the Balmikis.
That's right.
Right? So, to that extent to which the reservation is exclusively carved out for them, the other backward castes cannot compete for those posts which are set apart from them. So, in a sense,
in the first instance, they can't.
In a sense, it is in that sense exclusionary. We can't gloss over the point that it is exclusionary.
We can't.
The only question really is this: can that exclusion not be justified on the same yardstick that we have applied for the exclusion in the backward versus forward context?
Milord, if I had to put it very
Because within the backward, within
Yes.
the backward communities, within the scheduled castes, is there anything in constitutional jurisprudence which restrains the state from saying that I'm not deleting a community from the list of scheduled castes which has been designated by the President under Article 341 or 342, but within those communities, I am now making a classification that certain communities are more backward and therefore in greater need for protection on the same touchstone of substantive equality. And if that can be done by the state in reserving in carving out certain posts out of the competition of the general community, then why can't the state do it within the backward communities? That's really the
Absolutely.
point. But there is an element of exclusion, we must face it. I don't think we can gloss over it.
What this entire example that your lordships have given is based upon a very simple word, which is relative backwardness. Once we concede to the argument of relativity in backwardness, and it is the backwardness vis-a-vis the forward which brings them into the 50%, and it is the further more backwardness within the 50% which gives them the reservation within the reserve, then this argument has no problem.
Now, Chinnaiah said, Chinnaiah's whole rationale was this, that the power to designate communities as scheduled castes and scheduled tribes exclusively belongs to the president and now therefore
Absolutely.
Parliament. For instance, in Milind, we
That's
have got
true.
all those Palghat Jilla Thandan, Milind Katware, which came from Maharashtra.
That's true.
It is not open, for instance, for the court to say that though this community is designated as a scheduled caste, another community is part of the designated community. You have to take
Can't
the
do.
list. You can't do. Our court is that jurisprudence is now very, very well set.
That power has been reserved.
You can't tinker with the list.
That power has been reserved for the parliament, remains so.
That's right. But the argument which seems to have found favor in Chinnaiah was this, that if that is so, then the state cannot classify within the list of communities which are designated as scheduled castes, because to make that classification would amount to an exclusion of some communities within the scheduled caste. That seems to be the logic.
Yes and no.
I mean, very simply put, that's really the heart of the controversy.
Because Chinnaiah, in my humble submission, was a plane which took off from the wrong runway.
And your argument would be, I guess, that you're not deleting any community from the list which has been designated by...
There's no exclusion.
There's no exclusion. But within the quota, you are saying...
why should not there be exclusion? According to you, amongst a particular category,
Please.
some of these subcastes have done better. They are the forward in that category.
Absolutely.
So they should come out of that and compete with the general. Why stay there? And let the remaining who are still backward, within the backward, let them have the reservation.
My lords are absolutely right, but there are two ways that this whole concept...
achieve the concept of reservation.
That was the
They
aim.
should move out of that category.
That is the aim.
Yes.
And if the aim is achieved, then the purpose for which the exercise was taken should come to an end. Because nobody, my lord...
No, aim is achieved according to you for certain subcastes in that particular category.
Within. My lord, so that's why I'm saying it works in two ways.
They have achieved, they should come out and the remaining should get that benefit.
Yes. Now, my lord,
argument
what your lordships are suggesting...
Your argument appears to be that amongst the backward, there are more backward.
Yes.
And therefore, they require a more special treatment than the backwards.
Yes. But what Justice Nath is suggesting is the ultimate.
Advocate General, your argument also would be at two levels. One is the equality argument, and the other is the federal argument, which you also made. One, the equality argument postulates that it is open to the state to classify within the scheduled castes by identifying those who are really, really within them in a state of relative marginalization.
Absolutely.
That's the substantive equality argument. And if you can do that between the general communities and the backward caste, why can you not apply the same principle?
The same principle there.
The second, of course, is the federal argument.
Yes.
That every state within the nation is peculiarly conversant with the conditions of the castes and communities which are prevalent in that state.
So right.
And therefore, what Parliament has done is to designate castes and tribes for the entirety of the nation. But that does not take away the power of every state within its own territories to say that, well, these are the communities within my state who are particularly marginalized and are worthy of special attention.
Benefits, as they call them.
Special benefits. And there is nothing in the constitutional structure to prevent the state from doing that, because it ultimately owes responsibility to its own residents.
Absolutely. But now, what Justice Nath was saying is the ultimate argument, which they rightly note is for the Parliament.
You must have done some exercise.
Yes.
In identifying
the backward within the backward.
Within the backward.
And
like
because of that,
Madhabis and Valmikis.
Absolutely, Malad. Now the issue,
what are the parameters or the considerations you've taken into in identifying?
Various reports, Malad, which show that those people are two things. One, they continue to be backward, and or in spite of being what they are not adequately represented in services under the state. These are two parameters. One, are they really the backward within the backward? Two, whether they are backward within the backward or not so backward, or forward backward or backward forward, they are still not represented. So there is something lacking somewhere in the matter of policy. And that is what the state seeks to address.
Now, Mr. Advocate, do we have some population data on what is the total population of SCs in Punjab, and what is the population of the Balmikis and Mazhabi Sikhs within that group of SCs?
We do. They are all statistically available. But why I am not stressing upon that is because the reference to your lordships primarily.
It's not a numerical argument. It's not a numerical argument.
It's not a numerical argument. The argument is, first of all, can you do it? As Justice Nath has correctly put, can you do it? If you can, and the answer is yes, who is to do it? Parliament, state, executive, legislative. And if who is to do it is determined, then how that state is to do it? How is not the issue before your lordship?
You sort of laid down the jurisprudential framework in the first part of your submission.
Please.
Now, why don't we go into the nitty-gritty of it?
Yes.
Show us the statutory provision.
I will come to that in just 2 minutes.
Then we look at Chinnaiah.
Yes.
And why we look at the law before Chinnaiah and after Chinnaiah. Chinnaiah is 2005. Chinnaiah has then been overtaken by a lot of law on the subject.
Absolutely. Now, Millard, why I'm trying to distinguish that argument is that Chinnaiah proceeds on the basic premise that exercise of power for the purposes of identifying the backward within the backward
is only of Parliament.
Is only of the Parliament, and any exercise by the state to that effect tinkers with that power. What Chinnaiah has possibly failed, we'll go through the judgment and see if I'm correct, is that 16(4) is an independent provision which has to be exercised by the state, either center or the state government. The powers which give the enabling provision, an exercise to be conducted by forming an opinion, is totally within the legislative domain and the executive domain of the state government. There, Parliament does not figure. So the distinction is, Milord, for instance, that there is a room in which benefits are being provided. In common parlance, 341 and 342 are the pass with which you get into the room. That's all. Are you entitled to be in the room or not? The president decides, first list, which is a one-time exercise by the president, that whether you're entitled to be in the room or not. Then, as common culture goes, we have VIP passes. So then the Parliament decides that whether who's in the room is entitled to be in the room or to be displaced from the room, or who's outside can be given an entry into the room or not. There are two different exercises. One is a one-time exercise by the president. He issues an order in 1950 for Punjab, let's say, that these 26 castes are entitled to be in the room for the purpose of benefits which the scheduled castes are entitled. Understood? Thereafter, that power is taken away from the president and vests totally in the parliament, that whether those inside, as your lordship put it, are entitled to remain inside any longer or not, and whether those outside have reached a stage where they now become entitled to be inside. So what is very interesting is that even the Constitution in 341 and 342 accepts this exercise to be a two-way street. The power of the president is a one-way street. Once you issue an order, in common words, you become functus officio. You cannot touch that order on the executive side anymore. Once that exercise has been done, then forever, the parliament will remain vested with the power to legislate,
to include more communities,
to include more, or to exclude.
Absolutely.
So my lords were right. That power to exclude, that you attained that forwardness, which does not anymore entitle you to be called as a backward class. You have to exit the room and make place for other people, as your lordships have put it, my lord.
So taking further the concern expressed by my learned brother Justice Vikramnath, if within a particular backward class,
Please, my lord.
certain castes have reached that position and they are on par,
Please, my lord.
then as he pointed out, then they should move out.
They should exit and make
but then that is again for the parliament to.
only for the parliament. Only.
But then since
Now, that is
since
what
we are deciding an important issue,
Please, my lord.
just giving a thought for consideration
Yes,
of
my
all of
lords
us.
my lords are absolutely right.
Now what happens? A person from scheduled caste or scheduled tribe gets into IAS, IPS.
That's right.
So once he's an IPS, IAS, IPS, IFS, his children no more suffer the disadvantages that the persons from the category who are residing in the villages are
My
suffering.
lords are right.
But then, by virtue of reservation, they are also entitled to get in the second generation.
Therefore,
Second,
it is
And again the third generation. So,
somebody only and
so-
not cutting the general.
So your
beg your pardon? So, criminal is not available for scheduled caste, scheduled tribe. Criminal
now it is. Now it is, my lord, after Jarnail. Now it is. But that's again, my lord. Yes.
Yes.
So that is not the area I'm immediately coming to, but just to take the example forward of what my Lord Justice Gavay has pointed out, my lord. Who enters or exits the room? Let's put it as a two-way street. Who enters or exits the room is the prerogative of the president, followed by the parliament forever.
But you are saying the distribution of
The
benefits
distribution of the
within-
sweets and the benefits inside the
for
room.
those who are already within the room is for the state.
Yes,
Yeah,
my lord,
that's
to
what
say
the
that those who are underweight will be given a free meal. Let us take it that's the title to be in the room for those benefits. Very well understood. A person is 49, he's still in that room. There's a person who's 27 kgs who needs it far more. Are you going to treat both of them equally?
But let me test the argument to its logical extreme.
Please,
to
Lord.
test the argument.
Please, my lord.
To test the argument. Can the state say that we are giving 100% reservation
No.
out of the scheduled caste only to these two communities?
No, my lord. Cannot be and should not be. Why?
Why?
Because then you are excluding. Without legislating, you have virtually done
There
what
you
only
have a
341
problem.
can
You
do.
have a problem there. Because even if you are making it short of 100%, exclusion is implicit. So you can't place it on the exclusionary argument.
Lord,
100% is an absolute exclusion.
that's true. That's true.
But 50%
That's
is
true.
an exclusion qua those who can't compete for that 50%
Malords are right.
within the backward.
Malords are right, my lord.
So
Malords are right.
there is an element of exclusion. So we'll have to answer it if we have to in saying that Chinnaiah has overlooked our jurisprudence, that we can't place it on this that, look, I'm not excluding. We'll have to place it on a more sound jurisprudential foundation.
Whether it's preferential treatment.
But what he argues is they have applied the principle of 50%,
That's right.
which is considered as a Lakshman
Malord,
Rekha for
yes,
reservation.
because in
So
institutional
there
preference.
is no complete exclusion.
There's no complete.
Malord, institutional preference in medical.
Even otherwise, even by providing 50% reservation for backward classes, you exclude 50%
For the general
for the general community category.
That's right. And that your lordships have upheld. Indira Sahni, Malord, which of course went into this issue in detail, said that otherwise you will be inhibited in taking up any exercise qua reservation Because if you say that you cannot do it because it amounts to exclusion, it will not be the intent of the Constitution. If you have to do it, whether you can place checks and balances on it is the intent of the Constitution. And that 50% is, of course, a judge-made law. Where your lordships have held, let's be fair.
But I go one step further.
Please.
Is the state bound by the 50% cap while applying the distribution of benefits within the 50%? Why should we? I mean, why should we? It's very, it's otherwise not very attractive. But is the state truly bound by that 50% cap within the backward? Can the state not say, look, in my state, these communities are, these are the truly marginalized communities. I want the benefits to go to them.
Yes.
I'm not breaching the cap insofar as the general communities are concerned.
Yes.
I'm not ousting equality of opportunity for them.
Mullah, right.
But within my state, these are not, okay, these are two here. Maharashtra may say or Tamil Nadu may say, no, it's not two, it's 7 in my state. It may say maybe 15. Can the state do that or can they not do it? Why can't they do it?
I'll try and answer it. But when we talk about provision of reservation, let's be very clear that there is no mandate by law. There is no mandate by law to provide reservation. Therefore, 15 and 16 are enabling provisions when we talk of clause 4 and 4.
Indira Thani, my lord. I disagree with that.
But
because that
we are only
classic
developing an argument. We are only developing an argument. To provide for reservation, my lord, what has broadly been laid down.
Enabling provision.
Yes, there are 4 checks and balances.
Though Indira Thani says that even if sub-article 4 of 16 was not there, still the state would have been empowered to do reservation because article 4 emphatically states what is implicit in 16.
That's article 46 and the consequences
for unequals.
Yes, that you will take care of them. That is your obligation. How you will do it, my lord, then there are powers to be exercised. But there are 4 checks and balances, my lord. I can share them at the outset with your lordships, which eventually...
Why don't we do this? Why don't we now look at the judgments and see, what is the area for maneuverability?
Yes.
What is now?
I'll just answer that question in short. So what your lordships have determined, my lord, one is backwardness, which I have submitted before your lordships is relative. Backwardness in the case of OBCs has been held to be a determinative factor, that whether you are backward or not, the state will decide. In the case of scheduled castes, your lordships have held backwardness is presumed. You cannot go into the exercise of determining the backwardness if you're a scheduled caste. The second factor, my lord, is inadequacy in representation in public services. Now, this is a data-based concept. Just answering my lord Justice Chandrchud's question. This is a data-based concept. It's statistics. Are you adequately represented or not? Though, my lord, that word can have a lot of connotations because they do not say equally represented. So we've never gone into that. They do not say equally represented. It can't be that they can ever be brought at a common platform. Maybe, maybe not. The word used is adequately represented, and that opinion, again, is to be formed by the state. The third, my lord, is the concept of creamy layer, what my lord Justice Vikramath had put it, that once you've achieved it, do you still get the entitlement to remain within the backward classes or not? And the fourth, of course, is efficiency of services. That whether provision of such reservation will eventually amount to compromising the efficiency of services under 335. Because that is also your constitutional obligation.
Therefore, Indira Thani says that there can't be reservation in certain type of post.
Yes, certain type of post, not beyond 50%, not without going into the checks and balances. So therefore, the exercise, not in my humble submission, is pretty comprehensive. Your lordships are right. Why a state cannot give 70 and the other state give 30 and the other state give 20? When they do it, it will be up for judicial review based upon the quantifiable data on the strength of which such a decision has been taken.
So has this exercise been
done in Punjab? Yes. I'm sure in Tamil Nadu, yes. I'm sure whichever state has done it, they are expected to and would have carried out this exercise. But that, as I was saying, my lord, a 3-judge or a 5-judge bench will decide that whether that exercise which has been done is susceptible to judicial review, and if so,
the High Court struck it down only on the ground
Yes,
of
of Chinnaiah. Only on
Mainly
Chinnaiah.
that you cannot classify further for the
That this
distribution of the
amounts to tinkering with 341. That was the entire sum and substance of it. And in Devendra Singh Malad, their lordships held that that may not be the correct view. Because 341 and 16.4 operate in two distinct legislative spheres. They have no overlapping as far as their implementation is concerned, because as I put it, 341 decides who's entitled for benefits, who to be given how much. Within those entitled is the exercise by the state. So therefore, Mulad, my humble submission was that unless this exercise is permitted by law, if you block it, then what your lordships call will happen is the word called lumping. Then all the benefits will be lumped upon a part of the part. And the others who are truly deserving, for whom these provisions have been made to achieve the eventual end of equality, will never get it. My lords have rightly put it, my lord. Justice Gavai, IAS, IPS. Lord, even if somebody is an inspector, his family has made it. His children will go to a good school. He will be in a city or a town or an urban estate. But for somebody who's still sitting in that part of the village from where you're not allowed to draw water from the well, he's the one who needs it. You cannot allow lumping of benefits with a certain class within a class. And if touching that class within a class is taken to be tinkering of 341, Lord, in my humble submission, that would be an erroneous legal view. And my lord, nobody intended reservation to be a perpetual concept. Nobody, not even the constitution framers felt, because we've had studies, we've had Mandal commissions, we've had judgments. Nobody wanted that reservation should remain in perpetuity, because eventually then that would mean that the exercise of reservation itself has failed. The idea is to achieve equality in the lowest time frame possible. Mulaz are looking at the clock.
You know, I was just going to tell you that the problem on being on this side of the bench is that clock constantly, ticks in my face. So
I understand your lordship's point that this is definitely at the cost of some other case.
This is the core of the matter. You've laid down your jurisprudential foundation, no doubt about it.
Very well.
We can now.
Now, my lord, let me start with the statutory provision. Now, my lord, before we go into, my lord, anything at all in this matter, before we go into anything in this matter, my lord, what is very essential.
Where do we get the act actually? You can just tell us.
The act is a part of the
now we'll go to the
volume 4, page 1, my lord.
Volume 4,
after the index, my lord, there is the Punjab Scheduled Caste Act. My lord, have it?
Volume 4, page 1.
Page 1. And your lordships would have the offending provision at internal page 3, which was section 4 and subsection 5.
As a first preference from among the scheduled castes.
Please,
as a first preference
yes,
from among the
yes,
scheduled castes.
yes. That is what I was trying to, Lord, impress, that it is not exclusion in the sense that we take it, but it is only first preference amongst the scheduled castes, and then
and if available.
Yes, then it will remain within the scheduled caste. Nobody will be denied the benefit by virtue of this clause. 366.24. Because we need to now see who are we dealing with.
That is also part of volume 4, or you want us to take the book?
Mulad, whichever way, Mulad. Constitution is not. Mulad may have the book because the entire Constitution we've not. Yes, we've not put it in the compilation. In this Constitution.
This is Mr. Shankar Narayan's gift to the legal profession.
This.
The good part about this is that, it has footnotes tracing the entire legislative history. So right at one point, you don't have to then flip between amending acts and amending statutes. Constitutional amendments.
It is a book which by habit every lawyer should carry in his breast pocket. I know your lordship's affection for the Constitution. Breast pocket.
My courtmaster says the library has purchased this.
No, but Mr. Shankar Narayan gifted us with one copy, I think.
Last time Mr. Shankar Narayan had given
that 370
must have gone home, I think.
You can sign it and give it to me.
we have it on our table in the residential offices.
So, my lord, if your lordships have 366, it says definitions. In this Constitution, unless the context otherwise requires, the following expressions have the meanings hereby respectively assigned to them. That is to say, my lords may straight away come to 23. Schedule, my lords have it. Schedule means a schedule to this Constitution. 24. Scheduled castes. Now, my lord, if your lordship would realize, this is kept in inverted commas. Scheduled caste is defined as means such castes, comma, races or tribes or parts of or groups within such castes, comma, races or tribes as are deemed under Article 341 to be scheduled castes for the purposes of this Constitution. So the definition has been directly linked with 341. And similarly, in the case of scheduled tribes, Mulad, it means such tribes or tribal communities or parts or groups within such tribes or tribal communities as are deemed under Article 342 to be scheduled tribes for the purposes of this Constitution. So we'll straight away go to 341, Mulad, because that will tell us, though the language is quite paramaterial, Mulad may have 341. The only thing we will get from there is who can do it. Yeah, I mean?
Yes.
1. The President may, with respect to any state or union territory and where it is a state, after consultation with the governor, thereof by public notification, specify the castes, races or tribes or parts or groups within the castes, races or tribes, which shall for the purpose of this constitution be deemed to be scheduled castes in relation to that state or union territory as the case may be. So, my lord, I'll just analyze this in a very short while. It's very clear that the authority, my lord, empowered to do this exercise under 341 is the president under clause 1. Now, when he's exercising this power, my lord, with respect to any state or union territory, and when there is a state in consultation with the governor. So this is, my lord, the consultative process which is undertaken. There is no dispute regarding the issuance of an order. And it is to be done by way of a notification, no problem. The interesting part starts after notification, and which is very germane to the present controversy that I'm arguing before your lordships. Why? Because even while defining as to for whom 341 can be exercised, it is not a monolith block. Well, may kindly take note of it. When 341 itself says that it has to specify a caste as a whole, comma, races or tribes, or parts of or groups within castes. That means a caste can most certainly be split. It's evident. If caste was so sacrosanct that anything would amount to tinkering with the caste, then 341 would not be couched in this language. Because the president can choose that this caste, for instance, I'll give your lordships an example. A caste is a scheduled caste in Punjab.
May not be in Maharashtra.
The same caste may not be in Maharashtra.
That's why somebody who's designated as a scheduled caste in Punjab,
yes,
if they go to Maharashtra, they may not get the
they
same
will not
benefit.
take it.
They will not get the same benefit.
And
also, at one time, there used to be territorial restrictions, which were abolished after 1976. So even though you were designated as a scheduled caste, you could get the benefit only if you belong to that particular region in your state.
Right.
Districts.
Districts, yeah.
Quite.
Now, after 1976, the territorial division was done away with, but it was there until 76.
It was there. So, my lord, very interestingly, your lordships have rightly put it.
Certain tribes in Chandrchud district of Maharashtra
May not be.
Would not be in the other parts of the state.
So, my lord, yes, that is what I was coming to. That the same caste in one state may not be a scheduled caste in the other. The same caste may be a scheduled caste in a state, but may be a scheduled caste only in a particular district of another state. The same caste, my lord, may be commonly designated as a scheduled caste for many states. So therefore, they say that all will be defined in the part to the schedule. But therefore, the definite conclusion which arises from reading this definition is that caste in itself is not an indivisible entity, number one. And under definition of 341, it most certainly is not a monolith block. It is not something which is to be taken as eradicator of birthmarks. No. We all know the birthmark philosophy, my lord, that once you become a scheduled caste, then you lose your birthmark, you're only a scheduled caste. It doesn't happen in 341. There are two reasons why. One, that as we have not already seen, a caste, once it enters the scheduled caste, may be a scheduled caste in a state or a district or more than one state. So therefore, you will have the benefits of the schedule only if you are within the definition so ascribed to you in the order issued by the president as amended by the parliament. That thing is very clear. Two, why it is not, my lord, a monolith is because it is a reversible process. It is a reversible process. Today, you can say that a caste is a scheduled caste in 3 districts of Punjab. For instance, I'm only taking an academic example. Tomorrow, you may reverse that status for one of those 3 districts also.
But now area restrictions are not possible.
No.
It's been done.
The parliament can say that this scheduled caste has, suppose it is located next to an urban center, people of that particular district have risen in affluence and have the opportunity to compete. They may exclude that district. The parliament may, in its wisdom.
The parliament has a power because any group of persons in that caste also.
Yes, that's right. So therefore, it's not an irreversible process. So therefore, when you are saying that even within a caste, you can create parts. And Mulot, for this, all we have to do is we'll go to the presidential order in respect of any state, and this example will be Mulot laid bare as to what I'm trying to say. Now, the issue is, why are they called scheduled castes? Because this word has become very generic. He's a scheduled caste. Why? Because his caste for that particular area is contained in the schedule. That's all. A scheduled caste is not a caste, as we commonly think. A scheduled caste is a person whose caste is included in the schedule for a particular area of a state or variation thereof in the manner that we have discussed.
If a parliament removes a particular caste from the schedule,
it can remove a caste.
That caste would cease to be a scheduled caste.
Can cease to be a scheduled caste. That doesn't mean he is not a caste which was backward, is backward, or continues to be backward. But if the parliament in its wisdom removes that caste, or the parliament in one context removes a part of that caste, or a group of that caste, because there's a lot of interpretation, Malaj were right, given in millions and other judgments, that you can either put a comma where there are castes which denote the same category of people. They are known by different names. Or you can put a subcaste in a bracket.
That is not permissible. It can be done only by parliament. The court can't
I'm saying you can. You meaning the parliament. The parliament can do it. That they can amend it, put a subcaste in a bracket along with the main caste. They can put a comma and add a caste to a particular entry where the caste is synonymous with the caste already entered. Or they can add or delete a part of that caste on a territorial basis. This power is endowed to the parliament most certainly, and that, my lord, has been recognized by your lordships. Now,
in fact, 15.4 specifically, Article 15.4 specifically refers to the scheduled castes and scheduled tribes. 16.4 has no reference to scheduled castes and tribes at all. It refers to any backward class of citizens
so your lordships,
who, in the opinion of the state, are inadequately represented in the services of the state. Now, because 16.4 uses that generic expression, any backward class of citizens,
yes,
that will of necessity include the scheduled castes and scheduled tribes.
That's right. That's right. But 15.4, your lordships are aware, came later.
Right.
It was by way of a subsequent amendment. So maybe by the first amendment, the Lord framers got a little wiser that why not specify? Why not specify?
Because of that Champakaran Dorai.
That's right. It was a result of Champakaran's judgment. So the effort was to make the intent very clear that when we say backward classes, as in 16.4, we mean backward, scheduled caste and scheduled tribes. Though that will not have an effect on the merits, because the backwardness, Mullet, the only thin line that we've seen has been drawn is that backwardness in case of OBCs can be tested, while backwardness in the case of scheduled castes and scheduled tribes is presumed. A state cannot go into the exercise of determination of backwardness as one of the 4 parameters for grant of benefits. Now, my lord, the only word I was struggling with, and I was looking for guidance from your lordships, is this word deemed, my lord. I was discussing with Mr. Farasat also in the morning. It troubles me. Why would the constitution framers use this word deemed? My only explanation was because it is not an exercise in perpetuity. So for that period of time, a deeming fiction is attached to that caste.
Oh, it could be read as deemed to be scheduled caste in relation to that state.
That's what I'm saying. So that is the
Once it
only
is included
explanation I could.
in the list for that state, it will be deemed to be scheduled caste for that particular state,
only.
and not for the other state.
Why I say so is that otherwise, normally as we interpret statutes, my lord, your lordships
So that
have
action
far more
committee
experience.
Clearly states that in relation to state has been construed
My lord,
to a particular state only.
if we take the word deemed out of it, does it change the sense of the article? Then it would be, shall for the purposes of this constitution be scheduled castes in relation to that state or union territory. Why deemed? I could not come up with an explanation, my lord, so therefore I'm leaving it, my lord, at that, because
The reason is that what Article 341 does is it recognizes the sociological existence of castes. Thus, the Article 342 recognizes the sociological existence of tribes.
that's right.
Having done so, it creates an artificial grouping called scheduled castes in 341
That's right.
and scheduled tribes in 342. There is, sociologically, there is no scheduled caste as such.
That's what I was saying.
Scheduled caste is an expression which the Constitution has adopted for the conferment of benefits on these communities. So therefore, it uses the expression deemed to highlight that this is really a deeming fiction which has been
We are
created by the
attaching to a particular caste, yes.
The existing sociological grouping consists of castes, which 341
My lord,
says
just
and
put it, my lord, just
342.
the way he said.
Or it could be read for the purposes of Article 46. So Article 46 refers to scheduled caste and scheduled tribes.
That's right.
And
No, but
so,
why deemed?
though 15.4 has come subsequently, 46 is from inception.
Quite right.
So it
My
will
lord,
be deemed to be scheduled caste, and 46 provides for special provisions for scheduled caste, scheduled tribes, and vegan sections.
and the caste, my lord, is by birth. Caste is by birth.
Second,
This is the deeming fiction.
Article 341 also contemplates that apart from castes, races or tribes can also be a scheduled tribe, a scheduled caste.
That's right.
It's not only a caste which can be designated as a scheduled caste under 341, but races or tribes can also be designated as scheduled caste because it says specify the castes, races or tribes or parts of groups within castes, races or tribes which shall be designated as scheduled castes. So it recognizes this could be an amorphous group of castes, races, tribes, groups within castes, races or tribes, or parts of castes, races and tribes, which can be designated. And therefore, the reason why they use the word deeming, deemed, is that it is really a fiction which is created for the purpose of this constitution.
That's right. The caste will remain, whether you're in or out.
The caste will remain, the tribe remains, the race remains, those groups within, they don't lose their identity. The identity as caste, races or tribes,
yes.
their sociological identity
Yes.
continues despite their being deemed to be scheduled caste for the purposes of the constitution.
That's right. That's the only explanation I could think of, my lord. And the other thing was, my lord, that if tribes can be scheduled caste, then it would have an overlapping effect which doesn't reconcile with the framing of the constitution. Then why have two different? If tribes can be a part of scheduled castes, then there is a separate provision for tribes in 342.
Right.
Under what article would the president issue an order of a tribe? It can't be either under 341 or 342.
But because 342 does not include caste and race.
It doesn't, but 341 includes a tribe.
It includes a tribe.
So therefore, an overlapping jurisdiction as far as the tribes is concerned.
But this is in recognition of the fact that, tribes and castes were not in that sense watertight compartments all over the country. In some states or in the case of some castes, that caste will not include a tribe at all. In other states, possibly the constitution took a broader perspective that there may be certain castes which are akin to tribal communities. And therefore, 341, they gave a much broader power.
Possibly.
342 says only tribes and tribal communities.
Right. Because there would be some states in India, my lord, where there are no scheduled castes.
Yes.
They only have a tribal community, which is
Like Andaman, Nicobar or...
Yes. Northeast, my lord, one or two states where they are classified only under 342. There are no orders of 341 in those states.
There are some states where there's virtually no scheduled tribe.
That's right. None. What's Punjab? My lord?
Punjab,
That's
Punjab, Haryana could be.
None.
the reservation was scheduled
Many
tribe were on the
tribes
ground
came and
of,
went from Punjab, my lord.
they were on the ground of geographical handicaps.
That's right.
And whereas 341 scheduled caste is on the account of socio-economic backwardness.
Quite right. Like in Punjab, my lord, we have Sikri and we have Rai Sikhs. Rai Sikhs were a criminal tribal community, but they're always been categorized as castes. So different headings were given to them, one which has been entered now.
Exactly, that's very important because that shows that though they were essentially tribes,
Yes,
they have been classified as castes for the purpose of Article 341.
that's right. So therefore, what we have to understand is that the president issues an order which may or may not be not in perpetuity. We have to understand that. Because while issuing the order, what the Constitution very fairly recognizes is that the president, after the issuance of that order, cannot change that order. So in case there is any error in the order issued, or in case because of the sociological conditions, a caste or a tribe or a race needs to be added to that order, the parliament in its wisdom would do that exercise, which also is challengeable, my lord, on very, very narrow spectrum.
Where is the presidential order here?
Yes, I'm coming to that, my lord. Kindly have the schedule, my lord. Volume 4 is there, my lord, in the my lords have the volume 4. It is bookmarked, my lord. And if your lordship would have the second last document, the Constitution, my lord, is wrongly typed. It is scheduled caste order, and the third last is scheduled tribes. Kindly have the second last. Page 1371, it starts.
1371.
Now, what I've just, my lord, stated before your lordships would become clear from here. Lords have 1371?
Yes.
If your lordship would straight away come, my lord, to part 1, Andhra Pradesh. And if your lordship would have clause 4, that empowers, my lord, the interpretation by saying that any reference in this order to a state or to a district or other territorial division thereof shall be construed as a reference to state, district, or territorial division as constituted on the 1st of May, 1976. So when we see Andhra, my lord, if your lordship would come to 1372, entry number 9, my lord, it has all the contingencies that I was pointing out, my lord. It has a caste called Beda, if your lordship would have it.
In the districts of Hyderabad, Rangareddy.
No, first of all, it has Beda, then it has bracket, Budga, which means Budgas are also Bedas.
Right.
Jangam in the districts of, now Jangam is not a separate caste, but it's at the same entry, but only in selective districts of Andhra Pradesh. So therefore, my lord, in line with what the Constitution
Beda
says.
Jangam.
That's right.
Caste is Beda Jangam and it could be Budga Jangam also.
That's right.
It has to be read in continuation because otherwise there would have been
it's Beda Jangam.
Otherwise there would have been a comma in between.
That's right. There's no comma. So it's either interchangeable with Beda or Budga.
So it could be Beda Jangam
or Budga Jangam. Malod's are right. And in selective districts of Andhra Pradesh. Now your lordship would see, my lord, entry 30. There they possibly are synonymous castes which have been subsequently added, which are, my lord, Kolupul Valdu, Pambada, Pambanda, and Pambala. Now they are interspread with a comma, meaning thereby that the entry is one, but they may be interchangeable.
Either of them.
Yes. Why, my lord, this is very important is that if in such an entry, a person, my lord, who is born into one of these castes, say for instance, my lord, he is born as a Pambala, but he gets a scheduled caste certificate of Pambada, it will be recognized because it is synonymous and that will not disentitle him.
Like 14 also.
That's right. My lord, that's so right.
Chamar, Mochi.
That's right. Muchi, Chamar Ravidas, Chamar Rohidas. So they are all a part of one entry. When we come to this, it's a caste. Now, why, my lord, 341 was made sacrosanct is, we can just, my lord, refer to this and understand that, as my lords had put it, my lord, tomorrow a state feels that forget about the scheduled caste status of this caste. It has a population of 12% in my state. If I give them the benefit of scheduled caste by tinkering of the list of under 341, I can get voter friendly. To avoid that mischief, your lordships held, 341, as far as the entry and exit is concerned, is sacrosanct. No state in the federal structure will be able to tinker with the entry and exit or a caste or a part thereof, or a race or a group or a part thereof, while exercising the powers which are not vested in. That was the reason. What Milind and Mulot, the subsequent judgment, says is this: it is not for conferring of benefits at all, which Chinnaiah interprets it to be. It is not a theory of inclusion or exclusion at all. So therefore, Mulot, the principal argument that 341 and 16.4 operate in completely different legislative spheres. The word used there is state. It could either be center or the state government. And they can, in their opinion, confer the benefits which they are enabled to provide under 16 in the manner that they deem fit. The provision of those benefits in the ratio as the state decides is definitely open to judicial review, but it is not tinkering with the list. That is the principal argument on which we propose to, Mulot, seek the setting aside of Chinnaiah, is that it does not tinker with 341. So now, Mulot, would have the Punjab list, Mulot, which was an issue in my case. 1381, Mulot. Part 3. Now the statute said Balmiki because Balmiki is synonymous with Chuda and Bhangi at entry 2. And it said Mazhabi, which is interchangeable with Mazhabi Sikh at entry 23.
The statute uses the word Balmiki and Mazhabi Sikh. And Mazhabi Sikh.
Mazhabi Sikh. So Mazhabi Sikh and Mazhabi, as per the order, is interchangeable. It's interspread with a comma. And so is, my lord, Balmiki with Chuda or Bhangi.
But your Act doesn't say so.
Act doesn't say so, my lord. So therefore, we'll have to refer back to the Constitution to say if somebody holds a certificate as a Bhangi, he will be considered
Therefore,
for the benefit to be...
the benefit under 4.5, 4 bracket 5.
So that is the intent.
No, but then if you are giving that preferential treatment, it will be only for Balmiki or Balmiki, Chura and Bhangi.
No, we are giving to Balmiki as at entry 2 along with the caste entailed therein, and Mazhabi at entry number 23 with the caste entailed therein interspread by a comma.
Because there, according to the Constitution, has indicated that these other two communities are also synonymous.
Synonymous.
Or these are included in that
yes.
too.
Yes, yes.
So really the statute has used only one, Balmiki and Mazhabi Sikh.
That's right. Now, if your lordship would see, my lord, at serial number 37 is a caste called Sikri Bandh.
Yes.
And serial number 39 are two castes, which are Mahatam, Rai Sikh. Now, as the proposal of the state was, my lord, that Mahatam is the principal caste. And Sikribans are those people, my lord, who weave rope from jute. So Sikribans and Raisiks, which I was just referring to, who were a criminal community, used to engage in the occupation of weaving of rope and making beds and chairs with the help of that rope. My lord, they were engaged in that vocation. The proposal was that include Mahatam and Raisik with a comma at Sikriban. But the parliament decided, no, we will include them as a separate entity at a separate place, interspread with a comma, but not synonymous with Sikriban. Now, the problem is that a lot of people from Raisik caste and Mahatams had certificates as Sikriban because they actually belong to that caste. In any case, that litigation I'm doing in the High Court, so just sharing it with your lordships. So there, this whole interpretation of milind and comma and a separate entry, we are engaged in the debate, my lord, that whether if historically they are a part of the same community, engaged in the same vocation, which confers the same benefit amongst them as a caste, why should they be given the benefit not from 76, but from 50, when Sikriband was entered as a scheduled caste?
Now, Mr. Advocate General, we have seen why jurisprudentially you are saying that Chinnaiah is not a correct, has not interpreted the constitution correctly, because there is no question of inclusion or exclusion.
That's right.
16.4 is enabling.
Enabling.
341 designation.
That's right.
Now, should we go to the judgments and see?
Lord, we'll just read quickly 15 and 16, my lord, because that is the whole basis of my argument.
There's only one distinction between 15.4 and 16.4. 16.4 doesn't use the word any.
Any.
Which 15.4 uses. Does that make any difference?
Lord, there are
because
two things.
15.4 says any, may provide benefits for any socially and educationally backward class of citizens.
My lord, 15.4 says special provision.
Special provision.
And 16.4 says any.
Right. No, 15.4 says any.
No, my lord. 15.4 says special provision.
For making any special provision.
That's right.
For the advancement of any socially and educationally backward classes of citizens.
Oh, your lordships are talking about the second any.
Yes, the second.
All right. So, my lord, and there is a difference. If your lordship would have 15,
no,
my lord, first.
Why I'm asking you is.
Let's just read 15.4 and 16.4, my lord.
Right. Let's see 15, 16.4.
Because the other, my lord, sub-clauses are not relevant. It says nothing in this article or in clause 2 of article 29 shall prevent the state in this case meaning either the center or the state, from making any special provision for advancement of any socially and educationally backward classes of citizens or for the scheduled castes and the scheduled tribes. Now, my lord, the word here could have been anything, because instead of or, the word could have been including. It is not including. So when we see the intent, it means that it distinguishes backward classes.
I didn't get you.
But if your lordship would see the word between backward classes of citizens or for the scheduled castes and scheduled tribes. It can have two meanings. One, that you can make a law exclusively for backward class of citizens or for scheduled castes and scheduled tribes. But in definite form, it recognizes the distinction between backward classes and scheduled castes and scheduled tribes, because in 16.4, the deeming inclusion of scheduled castes is there in backward classes.
Because this
wait.
Come after Champakaran. So
that's right.
Maybe she was belonging to scheduled caste.
That's right.
And that GO was challenged wherein the reservation was provided for scheduled
Madras GO.
Madras GO.
They said, and our court said that you cannot have community-based reservations in admission.
That's right.
So
that has got to be taken away.
It should not
be
communal.
Scheduled caste and scheduled tribe is there, but 16.4 was there from inception.
That's right. Now, if your lordship would see,
you know, the only thing, I mean, nothing will turn on this case, but there's a little issue here. 15.4 says from making any special provision, that means any kind of special provision.
That's right.
For the advancement of any socially and educationally backward class of citizens. That is, the state can pick out any socially and educationally backward class of citizens, because there is no it's not like a presidential designation here. Or for the scheduled caste and scheduled tribe. Can the state under 15(4) say that I'm going to make a special provision for only these scheduled castes in my state or these scheduled tribes in my state? Or is it bound, if you make that special provision, that it must apply to all scheduled castes and tribes in the state? Because any in 15(4) qualifies only the former, especially socially and educationally backward classes of citizens and not scheduled castes and scheduled
That's right. That's right. So as far as the scheduled castes and scheduled tribes are concerned,
you must treat them together as one unit.
You may make the provision for all, but as far as the internal, that will come in 16(4), where you can limit, extend or reserve within that category.
16(4) is even more clear.
Yes, kindly have.
16(4) says, nothing in this article shall prevent the state from making any provision, like there any special provision, any provision for the reservation of appointments or posts in favor of any backward class of citizens.
Any backward class?
So, any backward class of citizens could include scheduled
castes and scheduled tribes, right?
In which case, the state can conceivably say that, well, though these scheduled castes have been designated in my state, in my opinion, out of them, only these are not adequately represented in my services.
So, my lord, this recording of opinion...
There may be 29. In Maharashtra, there will be X number of scheduled castes. You can say, in my state, the inadequacy of representation applies only to these.
That's right.
Therefore, I'm going to make this provision only for
only these. For these. But why 16(4) qualifies it, unlike 15(4), a recording of an opinion is necessary.
Of inadequacy of representation.
Inadequacy of representation, which is not in 15.
It's not there in 15.
So, 16(4) as enacted, my lord, in fact, places a check and balance on the power of the state when exercised, talking of adequacy of representation. So, therefore, those 4 checks and balances,
so really speaking, if you look at your textually, the Punjab legislative measure, which reserves, say, 50% for these two communities, Valmikis and Mazhabi Sikhs,
yes.
Can that also not be justified on the ground that in regard to the relative representation amongst the scheduled castes, these two communities are the least represented within the represented group?
That's right. That's right. So it can be either or. One, that they continue to be extremely backward.
And they continue to be the least represented in the services of the state.
And or...
Therefore, a more special treatment among the special treatment.
Yes. So that's why I qualified it in the beginning that it can be and or.
Quantifiable data and all is not before us. We are only on the broader context.
So therefore, in scheduled caste, that issue will come up. That issue will come up because when they say backward class, as far as scheduled castes within the backward class is concerned, you cannot apply the test of backwardness.
But you still have to
inadequacy of representation. Yes. 3 tests will still remain. Inadequacy of representation will remain. Then, my lord, efficiency of services as countered by 335 will remain. And, my lord, creamy layer, which is a law in progress.
Journal has applied.
Yes. My lord, that is still work in progress, my lord. But as it stands today, creamy layer will apply to scheduled castes also. Because within the backward classes, as defined by 16(4),
of the scheduled caste, there's a presumption of backwardness.
Yes.
Which there isn't in the case of the SEBC, especially and education, socially and educationally backward.
So therefore, this debate, my lord, that when there is a presumption of backwardness, but they have attained the forwardness to sever the umbilical cord which attaches them to the definition of backward classes, will they be excluded from the benefit or not? Nobody is saying they will become descheduled. Scheduled caste, they will remain, but they may not be entitled to the benefits which are under 16(4) to be given only to backward classes. So the moment they become forward enough to declassify themselves as backward classes, they will be disentitled to the benefits which flow from 16(4). Because creamy layer is not a caste-based concept. It is an individual concept.
It's an economic concept.
It's an economic, educational, or a sociological. It can be either. Could be either. That the caste has come up socially to a very even platform with the other castes, or educationally, most of them are educated, or economically, 5 families of that caste who shifted to the capital town have risen to an extent where, as your lordships not put it, that they have severed the link between backwardness and them. And the moment that link goes, then disentitled for benefits.
Now what next, Mr.
Yes, my lord. Lord, now your lordships would only have one more, my lord, article, which of course is, my lord, 46 your lordships have seen, my lord, we all know. Then, my lord, 335, which is one of the tests, my lord, which says the claims of members of scheduled castes and scheduled tribes shall be taken into consideration, comma, consistently with the maintenance of efficiency of administration, comma, in making of appointments to the services and posts in connection with the affairs of union or the state. So, my lord, why I say so that this is now relatable to entry 41 in list 2 and entry 61 in, my lord, list 1 and entry 25 in the concurrent list, which pertains to services. Though I don't, in my humble submission, think that there is any direct contact between the controversy at hand and the exercise of power of legislative or executive intent through those entries. I don't think, my lord, that will detain your lordships. But Chinnaiah proceeds on this, that you cannot exercise powers under 41 and 25 being a state, because this would amount to tinkering with the intent of 341. So, my lord, in my humble submission, that argument is misplaced. So, I will not dwell on it much. Then your lordship would have, my lord, commission for scheduled castes, which they say that everything has to be routed through them. And then the, my lord, 338A, which is for scheduled tribes. I'm just skipping them, my lord, because they may not be of relevance in this controversy. And 341 we've read, and the lists I've seen. Now, my lord, straight away we can come, my lord, to the judgments. In Chinnaiah, my lord, there are 3 orders. The first, my lord, which I'll read what has come to your lordships, my lord, is the reference order, volume 5, my lord, page.
Volume 5, there are 3 volumes, 5A, 5B, and
Page 1400, my lord, the third last bookmark.
Volume 5?
My lord, just one second. My lord, first your lordship would have 5A, my lord, because that is an order prior in time. Roman 5, small a. In this, the last bookmark, Davinder Singh, my lord, which is the matter before your lordships.
PDF page, would that?
Page 247 in volume 5, Roman 5, small a.
You have to put even in 5 it is there.
249. Volume 5, 249.
They put it in number.
PDF 249, my lord, the last order.
So this is not the reference order.
5A 249.
That's right. PDF 249, running page 247.
There is no 24. Okay. Yes. 5A 249.
This is in Civil Appeal 2317, my lord.
That is Justice Loda, Justice Joseph, and Justice Nariman.
This is the order of 2020, my lord, volume 8, SCC 65.
Though the order, interestingly, is of 2014.
It's a
I was wondering how a 2020
reported
judgment refers
in
to Justice
2020.
Loda.
Otherwise, an order of 20th of August, my lords may note. The order of 20th of August 2014 by a 3-judge bench.
Yes.
It says, my lord, the learned counsel for the respondents heavily relies upon the Constitution bench decision of E.V. Chinnaiah versus State of AP. On the other hand, the learned additional Solicitor General for the appellants submits that E.V. Chinnaiah has no application on the controversy in hand. Moreover, he submits that E.V. Chinnaiah is not in accord with the 9-judge bench of this court in Indira Sahni versus Union of India. Having heard the additional Solicitor General and the learned counsel for the parties, we are of the view that EV Chinnaiah needs to be revisited in the light of Article 338 of the Constitution of India and inter alia exposition of law in Indira Sani. Moreover, the matter also involves interpretation and interplay between 16.1, Article 16.4, Article 338 and Article 341 of the Constitution of India as well. In this view of the matter, we refer the matter for consideration of the above aspects by the larger bench. Let the matter be placed before the Chief Justice. Then comes the order, my lord, which I was earlier pointing out in volume 5, the third last bookmark, my lord. PDF page 1404, my lord.
Volume 5.
This is, my lord, an order of 27th of August 2020.
Volume 5, page
1404.
And in this, my lord, if your lordship would come to the concluding part of the judgment, which page is it?
So 3 placed it before 5 and then 5 placed it before 7.
That's right. That's right. Lords, in this judgment, if your lordship would kindly have para 49 on page 1460. PDF. Which is in contra to the earlier finding of Chinnaiah, providing a percentage. My lords have it?
Writing a percentage. Yes.
Providing a percentage of the reservation within permissible limit is within the power of the state legislatures. It cannot be deprived of its concomitant power to make reasonable classification within the particular classes of scheduled castes, scheduled tribes, and socially and educationally backward classes without depriving others in the list. To achieve the real purpose of reservation, within constitutional dynamics, needy can always be given benefit. Otherwise, it would mean that inequality is being perpetuated within the class if preferential classification is not made, ensuring benefit to all. The sub-classification is to achieve the very purpose as envisaged in the original classification itself, and based thereupon evolved the very concept of reservation. Whether the sub-classification would be a further extension of principle of the said dynamics is the question to be considered authoritatively by this court. And 52, my lord, they say what exactly is in the mind of the court. The state has competence to grant reservation benefit to the scheduled castes and scheduled tribes in terms of Article 15.4 and 16.4 and also of Article 341.1 and 342.1. It prescribes the extent / percentage of reservation to different classes. The state government can decide the manner and quantum of reservation. As such, the state can also make sub-classification when providing reservation to all scheduled castes in the list based on a rationale that would confirm with the very spirit of Article 14, 15, and 16 of the Constitution providing reservation. The state government cannot tamper with the list. It can neither include nor exclude any caste in the list or make an inquiry whether any synonym exists as held in Millen. And then, my lord, the next paragraph, 51. Coming back, my lord, the scheduled caste. Because of that transient nature of the list, my lord. The scheduled castes as a presidential list are not frozen for all time, and neither they are homogeneous group, as is evident from the vast anthropological and statistical data collected by various commissions. The state law of preferential treatment, to a limited extent, does not amend the list. It adopts the list as it is. The state law intends to provide reservation for all scheduled castes in a pragmatic manner. Based on statistical data, it distributes the benefits of reservation based on the needs of each scheduled caste. So, my lord, if at all there is an application of mind in 341 for inclusion and exclusion, the application of mind benefits, it will only under 16.4. Only under 16.4, no other provision. Should be. We can go back to Chinnaiah and see what weighed with their lordship's mind to give that judgment, and how it has been distinguished, my lord, in Devender Singh reference order. And, my lord, I'll come to the other judgments like Indra Sani, my lord, that is more generic in nature. Chinnaiah is, my lord, volume 5, my lord, numerical 5, page 774, my lord. PDF is 778, my lord. It's the 6th bookmark after the index.
774.
778. PDF 778.
PDF 778.
PDF 778.
Yeah.
But the principal judgment is by Justice N. Santosh Hegde on behalf of himself and Justice Varyava and Justice Singh. Lord, what brought this matter to the Supreme Court, Lord, was the leave granted by the Andhra Pradesh High Court. The issue, Lord, emanated from a report of a commission headed by Justice Ramachandra Raju. And the scope of this commission was to identify, my lord, that within the list notified under Article 341 for Andhra Pradesh, please identify who had failed to secure the benefit of reservations provided for scheduled castes in the state in admission to professional colleges and appointment to services in the state. My lord, in pursuance of this report, the commission, my lord, opined that within the 15%, my lord, reservation for backward classes in the state educational institution and services of the state under 15.4 and 16.4, the scheduled caste, my lord, were primarily apportioned in 4 groups, my lord, in the following manner. They identified those 4 groups, my lord, in para 2. For reservation, my lord, group A 1%, group B 7%, group C 6%, and group D 1%, showing that group A and D were hugely underrepresented. Then, my lord, an ordinance was issued, and thereafter, which was, my lord, made an act of 2000. Both were challenged, my lord, and the matter came to this honorable court after the High Court dismissed the challenge by 4:1. Para 5, my lord, the contentions were, my lord, the contentions advanced on behalf of the appellants are that the state legislature has no competence to make any law in regard to bifurcation of the presidential list of scheduled castes prepared under Article 34(1) of the Constitution. Therefore, the impugned legislation being one solely meant for subdividing or subgrouping the castes enumerated in the presidential list, the same suffers from lack of legislative competence. It is further submitted that once the castes are put in the presidential list, the said castes become one homogeneous class for all purposes under the Constitution. There could be no further division of the said castes in the scheduled list by any act of the state legislature. His further submission was that in the guise of exercising its legislative competence under entry 41 in list 2 or entry 25 of list 3, the state legislature cannot exercise its legislative power so as to make a law tinkering with the presidential list, because the said entries do not permit any law being made in regard to scheduled castes. In guise of providing opportunity to some of the castes in list of scheduled castes in state cannot invoke entry 41 of list 2 and entry 25 of list 3, divide the scheduled castes according to the Learned Counsel for the impugned enactment does not really deal with the field of legislation contemplated under the said entries, but in reality is targeted to subdivide the scheduled caste. Alternatively, he submitted that the classification or subgrouping made in the state legislature amounted to subclassification or micro-classification of scheduled castes is violative of Article 14 of the Constitution. Then, Lord, 338(9) argument is there in para 7. Lord, we may come to Mr. Venugopal's argument in para 8. On behalf of the respondent, Shri K.K. Venugopal, learned senior counsel appearing for the state who led the argument on behalf of the respondents, contended that Article 341 only empowers the president to specify the castes in the presidential list and the parliament to include or exclude from the specified list any caste or tribe, and beyond that, no further legislative or executive power is vested with the Union or India or Parliament to decide to what extent the castes included in the scheduled caste list should be given the benefit of reservation, which, according to the learned counsel, depended upon their degree of backwardness. His further argument is that authority to decide to provide reservation or not, and if yes, then the quantum of reservation to be provided is the exclusive privilege of the state. In that process, the state will have to keep in mind the extent of backwardness of a group, be it other backward classes, scheduled caste, or scheduled tribe. Therefore, having found a class of persons within the scheduled caste as having been deprived of such benefits, the state has the exclusive legislative power to make such grouping for reservation under Article 15.4 and 16.4 of the Constitution, subject of course to Article 245, 246 of the Constitution, since in the instant case, there is no allegation that there has been any violation of Article 245, 246, the argument of lack of legislative competence advanced on behalf of the appellant should fail. He further submitted that there is an obligation on the state under Article 16.4 to identify the group of backward class or citizens which in the opinion of the state is not adequately represented in the service under the state and make reservation in their favor for such appointments, and under Article 15.4 of the Constitution, there is an obligation on the state to make special provisions for the advancement of scheduled castes and scheduled tribes. And what the state has sought to do under the Impugned Act was only to make such provisions to fulfill the constitutional obligation after due inquiry. Hence, the allegation of violation of Article 14 cannot be sustained. He strongly relied on the findings of fact recorded in Justice Raju Commission report, which according to him establishes that some particular groups within the scheduled caste have cornered all the benefits at the cost of others in the said list. Therefore, with a view to see that the benefit of reservation percolates to the weaker of the weakest, it had become necessary to enact the impugned law. The Learned Counsel submitted that by regrouping the castes in the scheduled caste list, there is no reclassification or micro-classification as contended by the appellants. Then, my lord, the basis of that report is given, which was on the basis of the Constitutional Assembly debates and so on and so forth. My lords, may straight away now come to questions framed in para 12. Must have it?
Yes.
Whether the Impugned Act is violative of Article 341(2) of the Constitution of India, whether the impugned enactment is constitutionally invalid for the lack of legislative competence, whether the impugned enactment creates subclassification or micro-classification of scheduled castes so as to violate Article 14 of the Constitution of India. Though my lord touched on fringes, surprisingly, the interplay of 16.4 and 341 was not even framed as a question. Completely dehors the constitutional power under 15.4 and 16.4. Because essentially the court proceeds on the conflict between 341 and entry 41 and 25. It was argued, but not, my lord, essentially, I would say, considered as it should have been. I'll now come to the findings starting from para 13, my lord. Yeah, my lord?
Yes.
We will first consider the effect of Article 341 of the Constitution and examine whether the state could, in the guise of providing reservation for the weaker of the weakest, tinker with the presidential list by subdividing the castes mentioned in the presidential list into different groups. Article 341, which is found in Part 16 of the Constitution, refers to special provisions relating to certain classes, which includes the scheduled castes. The article provides that the president may, with respect to any state or union territory, after consultation with the governor by public notification, specify the castes, races, or tribes, or parts of or groups within castes, races, or tribes, which shall, for the purposes of Constitution, be deemed to be scheduled castes in relation to that state or union territory. Now, my lord, here they give their opinion. This indicates that there can only be one list of scheduled castes in relation to a state, and that list should not can only be one, sorry, my lord, and that list should include all specified castes, races or tribes, or part of groups notified in the presidential list. Any exclusion or inclusion from the said list can only be done by the Parliament under 341(2) of the Constitution. In the entire Constitution, wherever reference has been made to scheduled castes, it refers only to the list prepared by the President under Article 341, and there is no reference to any subclassification or division in the said list, except maybe for limited purposes of Article 330, which refers to reservation for seats for scheduled castes in the House of People, which is not applicable to the facts of the case. It is also clear from 341 that except for a limited power of making exclusion or inclusion in the list by an act of Parliament, there is no provision either to subdivide, subclassify, or subgroup these castes which are found in the presidential list of scheduled castes. Therefore, it is clear that the Constitution intended all the castes, including the subcastes, races, and tribes mentioned in the list, to be members of one group for the purposes of the Constitution, and this group could not be subdivided for any purpose. A reference to the Constituent Assembly in this regard may be useful at this stage. What they rely upon is, my lord, while discussing 341, if your lordship would have the, my lord, in court part, the page is, my lord, bottom of 780 PDF 794. Para 14, my lord, it forms a part of. The object of these two articles, as I stated, was to eliminate the necessity of burdening the Constitution with a long list of scheduled castes and scheduled tribes. It is now proposed that the President, in consultation with the governor or ruler of a state, should have the power to issue a general notification in the Gazette specifying all castes and tribes or groups thereof deemed to be scheduled castes and scheduled tribes for the purposes of privileges which have been defined for them in the Constitution. The only limitation that has been imposed is that once a notification has been issued by the President, which undoubtedly he will be issuing in consultation with and on the advice of the government of each state, thereafter, if any elimination was to be made from the list so notified, or any addition was to be made, that must be made by the Parliament and not the President. The object, now, Lord, this is the italicized part. The object is to eliminate any kind of political factors having a play in the matter of disturbance in the schedule so published by the President. Because they felt that any kind of provision made to a group within the scheduled list will amount to political interference with the list. A discussion that ensued in regard to the framing of this article indicates that there was an attempt on the part of some of the members of the Constituent Assembly to empower the states also to interfere with the list prepared by the President under the said article. As a matter of fact, an amendment to this effect was also moved by Shri Kuldhar Chilla, who, while moving the said amendment, stated that the amendment 201 of list 5 in clause 2 of the proposed article 300B, after the words Parliament may, the words and subject to its decision the state legislature be inserted. Now, my lord, they give what was said in support of that amendment. However, my lord, I think we can skip that, come to para 19. Because eventually they hold that the original proposed article 341 was legislated. Para 19, my lord, this part of the Constituent Assembly debate, coupled with the fact that article 341 makes it clear that the state legislature or its executive has no power of disturbing, term used by Dr. Ambedkar, quote, the presidential list of scheduled castes for the state. It is also clear that articles in part 16 of the Constitution that power of the state to deal with the scheduled castes is totally absent, except to bear in mind the required maintenance of efficiency of administration in making of appointments, which is found in Article 335. Therefore, my lord, this is the finding. Therefore, any executive action or legislative enactment which interferes, disturbs, rearranges, regroups or reclassifies the various castes found in the presidential list will be violative of the scheme of the Constitution and will be violative of Article 341 of the Constitution. Completely per incurium, my lord, 16.4. Then, my lord, they say, we will now consider whether the scheduled caste list prepared by the President under 341 forms one class of homogeneous group, or does it still continue to be a list consisting of different castes, subcastes and tribes, etc. We have earlier noticed the fact that the Constitution has provided for only one list of scheduled castes to be prepared by the President, with a limited power of inclusion and exclusion by the President. The Constitution intended that all castes included in the said schedule would be deemed to be, now they say deemed to be one class of persons. That is nowhere in 341. But arguments have been addressed to the contrary, stating that in spite of the presidential list, these castes continue to hold their birthmark and remain to be separated, and individual castes, though put in one list by the president, it is contention of the respondents that by merely including them in the list by the president, these castes do not become a homogeneous group. Therefore, to fulfill the constitutional obligation of providing an opportunity to these castes, more so to the weaker among them, it is permissible to make classification within the class as was made permissible in this regard to other backward classes by the court in the case of Indrasan. We cannot accept this argument for more than one reasons. Then the second finding comes, not, it cannot be denied that all castes included in the presidential list for a state are deemed to be scheduled castes, which means they form a class by themselves. So, my lord, here, that age-old argument, my lord, and an example comes of a fruit chaat and jam. If the intention of the legislature was make it into a jam once they come into the class, then inclusion, exclusion becomes otiose. That means after it becomes a jam, you can't take out the apple from it and leave the peach inside. But if the option has been given to the parliament to keep one and take out the other, it remains a fruit chaat and not a jam. But the court proceeded to make it that once they come in, they all merge into one, birthmarks are lost, which in my humble submission is erroneous interpretation of 341. Then, my lord, Chinnaiah J, speaking in the same case with reference to the status of castes included in the presidential list, had this to say, quote, we may clear the clog of Article 16.2 as it stems from a confusion about caste and terminology of scheduled castes and scheduled tribes. This latter expression has been defined in Article 341 and 342. A bare reading brings out the quintessential concept that they, as I see there, are no castes in Hindu fold, but an amalgam of castes, races, groups, tribes, communities, or part thereof, found on investigation to be the lowliest and in need of massive state aid and notified as such by the president. Then, Malad, they interpret this comment in para 24. According to Justice Krishna Iyer, though there are no castes, races, groups, tribes, communities, or part thereof in Hinduism, the president on investigation, having found some of the communities within the amalgam as being lowliest and in need of massive state aid, included them in one class called the scheduled castes. The sequitur thereof is that scheduled castes are one class for the purposes of Constitution. Now, instead of recognizing, my lord, that it's a list of different castes, groups, parts of groups, they say once you come in, you become a part of a list. That list becomes the homogeneous class.
Your contention would be that merely because of their inclusion in the scheduled caste list, their birthmark is not removed.
Absolutely.
That still remains.
That birthmark will remain because that is the birthmark by which you will eventually be excluded by the parliament, or the benefits to be granted under 16(4) will be to a certain group or groups within that caste. You cannot say that today you are adharmi. The moment you come in the list, this would be a misnomer because that is how the society stands it. The moment you come in the list, you cease being an adharmi, you become a scheduled caste. Can't be. There is nothing called as just a scheduled caste. It's only, my lord, the inclusion in the schedule which makes it in common parlance to be called a scheduled caste. Otherwise, there is no caste known as a scheduled caste.
Yes.
Then, my lord, 26. Thus, from the scheme of the Constitution, Article 341, and above opinions of this court in N.M. Thomas, it is clear that castes once included in the President list form a class by themselves. If they are one class under the Constitution, any division of these classes of persons based on any consideration would amount to tinkering with the presidential list. And I'll resume.
About how long, Mr. Advocate, till now? After this, we'll take
About an hour and a half.
hour and a half.
This is the first judgment. The only thing is, once I read those judgments, maybe the repetitive content will not be necessary to be read. I am not going into the 63, 64 judgments because everything has eventually crystallized into 5 judgments. So, this being the first, it will take a little while. I'll try to finish
We
today.
did not go to the pre-N.M. Thomas judgments.
That's right. N.M. Thomas being very important.
Thereafter,
Then,
Akhil Bharatiya
yes, and Indira Sani,
Indira Sani really is then.
We'll have to see that because eventually what the law has come to be is that what is good for backward classes is good for the scheduled castes. So therefore, that connection.
Chinnaiah said, well, Indira Sani was cited in Chinnaiah, but they said, well, that is only for OBCs and not for.
That's right. That is the wrong interpretation because it is not. Indira Sani itself makes it clear that we are only putting aside the scheduled caste argument because we are not dealing with it.
We need to just look at that part.
Those paragraphs. Yes.
The reference order, in fact, sums up all of this.
Yes. They all, in fact, extracted the relevant parts of the.
Grateful.
Come back after lunch.